The fate of a former IRS investigator turned accused wife killer is in the hands of the jury. We're breaking down the evidence they're considering. And in New York, Luigi Mangione's team scores a big win, getting one of his murder charges tossed. What happens next for the accused assassin? Plus, the attorney who unsuccessfully went after rapper Cardi B for money damages last year is dealing with a money issue of their own over something they said to Cardi during the trial. The court of law is done for the day in those cases. Let's convene Court of Opinion. Welcome to Court of Opinion. I'm Jenaé. Thank you for joining us for a conversation with competing opinions on some of the biggest trials we are watching here at Court TV. We're in a verdict watch in Virginia in the Au Pair Affair murder trial. Prosecutors there say that Brendan Banfield was the mastermind in this plot. It's a disturbing one, to lure an unsuspecting man to have violent sex with his wife and then to frame that man for her murder. Now, the family au pair, who was just 21 years old at the time, testified about her relationship with the defendant and her role in the murder plot. But the defense says prosecutors took advantage of the young nanny and pressured her to change her story to fit theirs. The jury has gone home for the day and they'll pick up those deliberations on Monday. So let's take a listen to what they heard just before they went into the deliberation room, those closing arguments.
We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magalhães are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. The knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. You heard from Lieutenant Giacchio and former Deputy Chief Rouche that it was Iris Dalligraph's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. And you heard absolutely nothing from the defense about this evidence.
I chuckle a little bit when Ms. Sands says, we haven't proved anything. We haven't shown any evidence. All we've done is show evidence. All we've done is try to get the truth out there. My client doesn't have to testify, yet he gets up there and he tells a story. He's a philanderer. We can conclude that. He had affairs. He accepted that. He told you, ladies and gentlemen, exactly what was going on and exactly how it went. On cross-examination, he admitted to communications that were provided, letters between he and Juliana when she was in jail. She's referring to the expert that they have that I called. I called 3 times, and we dug for it. And he ultimately said the executive summary and the data remained the same. The only thing that changed is Juliana Perez Magalhães' statement. So there, number 1, that's the first time that anyone in this case, which was when I called him, conclusively said the entire catfishing theory changed upon her And that's a problem. That's a problem for their case.
Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Bristler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, what, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be.
Let's get right to our power panel. Let's bring in trial attorney Madeline Somerville, trial attorney Marlo Greer, and criminal defense attorney and civil rights attorney Gabrielle Higgins is with us. Can't wait to hear you all's opinions on today's closing arguments in this huge trial. We've been watching everything unfold, even the defendant taking the stand. Madeline Somerville, start us off. What was your opinion of these closings?
So much drama. Okay, so first of all, I can't believe the defendant took the stand, but I guess he needed to because he's the only one who could have concocted that story, right? He's the only one who could have told us that nonsense.
Even his defense attorney called it a story, by the way.
It was a bunch of nonsense is what it was. But I thought that the argument from the prosecution was fantastic. I thought she addressed the issue, which was probably the elephant in the room of the deal, the sweetheart deal, very well. I think she went out of her way to make sure that all of the bad facts she dealt with up front, which is the best way to do it before the defense comes in and tries to undo all the points you've made. And I think nothing is going to undo the nonsense that the defendant gave us and I think she really sealed the deal in her closing.
Marlo, what was your opinion of the closings?
You know, I wish I could disagree, right? Because that would be sort of fun.
Or contentious, right?
Exactly,
Yeah.
It would be contentious. I don't. I think she did an amazing job. I love the facial expressions. I mean, I don't know that I could bring more snark, and I really like bringing the snark, right? And she did such a good job of like, what are you talking about?
Yeah.
You know, she's gonna make 10 grand. That's gonna do what for her? She's 21 years old. How are we going to move forward? And the defense attorney, there were times when I just wanted to shake him.
Yep.
It's just, tell a story, tell a coherent story. I understand that your job is to sort of poke holes, right? But you poke holes in a way that somebody actually wants to listen to, as opposed to what happened here.
Let's get out to former public defender Gabrielle Higgins, see if she had a different take on the defense close. It was long, but he had a lot he wanted to get to, and he was clear that Juliana Magalhaes, that she was not on board with the prosecution side until after Brendan Banfield was arrested, and she was tired of being in jail.
Absolutely. I think at the end of the day, the defense has a job that they have to do. And part of that job is looking for the reasonable doubt where you can find it. And the reality is that this co-defendant, co-conspirator, she deserves just as much blame for participating in what was not only heinous, but actually gross and disgusting. I think at the end of the day, people choose their heart. And so you could just get a divorce. You could just own up to having an affair. Choosing to go to these lengths is something that the jury needed to consider, but it's not going to bode well for the defendant at the end of the day.
All right, let's listen back to one of the pieces of evidence from Prosecutor Sands. She talked about the relationship between Banfield and the au pair. He on the stand tried to act like, well, she came on to me. She said she found guys online who had the same name as me, that looked like me, and it wasn't really a big thing for me because I was in love with my wife. But take a listen how it was characterized on the prosecution's closing.
We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for.
Madeline Somerville, you're also a jury consultant, body language expert. When you're hearing the infidelity, a lot of times prosecutors like to make sure that is front and center because of how it impacts jurors, even if it's not a core element to the murder.
Sure. And I think that bringing up the sexual element of the murder itself, I think the defendant really did a major disservice in that, because he tried to make himself look like the victim in that as well. And I think whenever somebody tries to victimize themselves, if there is any doubt there, the jury is going to see that, and it's going to hurt his case tremendously. But I think an interesting piece of this, though, is that attorneys have been doing this forever, where they make definitive statements about exactly what they think happened, right? Because they have to tell the story to the jury. But if I were her, I would do it a little less. I would do it a little more suggestively, right? The evidence concludes this, not he was in love with her. This is what happened, because it makes the jurors feel like if I disagree with you at all, that I don't agree with your version. So I think she came on a little strong.
Marlo, what do you think about that? Gabrielle's trying to jump in.
No.
Go ahead.
Who cares if they're in love? Who cares? At the end of the day, the love only points to their conspiracy. It's not an element that they be in love to kill people. It has nothing to do with it. And if that's love, I don't want it. It has nothing to do with it.
Well, where I was going to go is, like, who would be searching online for a man that looks like him? I mean, seriously, like, what did she Google? Comb over? I mean, why would you do that? And so I really think that he's in love with himself, right? And that's the one thing that I feel like came across, the note-taking, answering the judge when they're talking about exhibits, and he's like, oh yeah, judge, that exhibit 78, yeah, that's the one. What are you doing? Like, shut your mouth.
Yep.
And so, I find that hard to believe, and I think you're right about coming on a bit strong that he was in love with her, although he did write her, what was it, a 35-page letter, 38-page letter?
There was a lot of exchanges before, because there was a almost 10-month period between the time that she was arrested and that he was arrested. So they continued this affair. He said he fell in love with her more after she saved his life.
Oh,
so
okay.
That explains away that he was, having this torrid affair, but more so that it was after the fact that he fell in love with her.
Yeah. I mean, sorry, Gabby, go ahead.
No, that was it. I was just saying, yeah.
Marlo, I want to ask you a specific question, because Brendan Banfield got on the stand and talked about Christine in a way that if he is lying, we don't know, the jury is going to make that decision, but if he is lying, he denigrated his wife, because not only is he saying that she invited her murderer to their home where their child was just minutes after their child would have left that home, but also that she would have been on websites where she was loving sexual violence, that even as a sexual violence nurse doing rape kits, that she somehow enjoyed it and was liking the things that she was seeing in documents. I mean, it's unbelievable. And to know what we do know about her from her loved ones, I mean, that's the part that really stings, that she has become the defendant in a way in her own murder trial.
And I think if there's anyone on the jury that has any information at all regarding medical type things, right? Not necessarily just sexual violence, but medical. What he said was, she brought those things home. And, she looked at them and he paused and he said, for a long time. It's like, okay, no. It's electronic medical records. Like, what do you mean she brought it home? Did she print it out? And how are you going to do that? I mean, that's not believable if anybody has medical knowledge. And so I think he's got to hope, like, no one has medical knowledge on that jury. And then the other thing is that somebody that works with sexual violence, like I do all of the time, I mean, I have to take cases that aren't sexual violence cases just to get away from it for a while. And I do not believe under any circumstances that a nurse who is processing rape kits is going to bring these things home, even if she can print them from the electronic medical record, and sit there and look at them for a long time. I really think they did a disservice to him if that's where, you know, if it was like, oh, sure, let's go with this defense. I don't think it helped.
We have to stop there for a break, but we're going to continue to talk about the Banfield case. We're still waiting for that verdict. Perhaps it'll be next week. The jury will start back deliberating in the case against Brendan Banfield, but we're going to look at the evidence against him, what this jury is weighing, and what we chose as the best evidence the Commonwealth put up and the best the defense put up. Stay with us.
Tonight on Closing Arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest Verdict Watch updates.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV. Next week,
covering the country's biggest trials before we bring you inside the courtroom. Plus, the most compelling true crime cases in our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
The jury deliberated today for 3 hours and 14 minutes in the Au Pair Affair murder trial for Brendan Banfield. Just enough time to probably pick a foreperson and start going through the evidence. So we're keeping the conversation going back to look at the most compelling evidence that both the Commonwealth of Virginia and the defense presented to this jury. The big question, who will the jurors side with? So first up, here's what our team chose as the best evidence presented by prosecutors. And it's this, the cast-off on the defendant's clothes. Now, a witness who specializes in blood stain pattern analysis. She testified about the blood found on Brendan Banfield's jeans. She said Christine's DNA was found on the jeans and then got into the specifics about why those stains themselves were important. Take a listen.
There are linear distributions of small circumelliptical stains. They're actually from about the knee to the crotch.
And are those stains cast off?
These stains could be cast off. They're consistent with cast off. We see some progressive change in shape looking across some of the lines. So cast off cannot be excluded as a mechanism to produce these stains.
All right, let's bring back in our guest panel, see what they think about this evidence. Madeline Somerville, Marlo Greer, and Gabrielle Higgins. Gabrielle, I'll start with you on this one. Cast off. Now, he was in the room with Christine. He says she was there, was holding her in my arms, so blood is everywhere. But in particular, the prosecution wanted the jury to see that this was cast off blood stain on his jeans.
I think it's effective, and I think jurors like to hear a lot of that technical jargon. They like to see and feel like they're walking through the investigation with the prosecution, and this is one of the examples of them being able to look at that evidence and argue back and forth on whether or not blood could actually transfer to his jeans in this way. So I think this is effective and something they'll hook their teeth into.
And so, Madeline, they're essentially saying when he's stabbing, when the knife is coming out, that blood is getting on his jeans in a particular way. Blood is everywhere on that scene and on him. But do you think it's the most compelling evidence? We really looked to see what the best is that they have. Do you agree with us?
So I agree with Gabby in that I think that the jurors love this kind of evidence because it's the kind that they see on TV. It's the kind that they can sit and talk about. But I think the best evidence for the prosecution actually was everything that came out of Brendan Banfield's mouth today or yesterday, because it severely contradicts all the physical evidence that we have, the timeline that we have established, right, and the character evidence. None of it comports. And one big thing that really was insane to me was so this poor woman was supposed to have been stabbed 6 or 7 times at this point, and she was supposed to have talked to you at that point. She's saying words. It defies, it's stranger than fiction, right? It defies belief.
It's not just words, it's, I'm sorry, honey.
Right, I love you.
What? What?
Absolving him from anything, putting it all on herself.
Yeah. And I'm bleeding out. I mean, is that really something that you're going to say, I am bleeding out? I don't think so.
Right.
You know, I actually do think the spatter is very compelling, but whether, you know, hey, is the CSI, the thing about CSI is those people are actually actors and they're interesting. And that was one of the problems with all of the lab techs. It's just, you had a hard time not falling asleep. This one, with the blood spatter, was a little bit more helpful. I mean, you know, juries kind of like a little bit of a Southern accent there, and so that's good, bring that in. But, you know, try to modulate your words, right? And so I think it is going to be compelling, and the fact that it's actually blood that's flying off of a knife, not that's being transferred to you from life-saving.
That's pulled. All right. So you mentioned the timeline and if there being a problem with the things that he's saying. So one of our honorable mentions was really evidence that the state didn't even know that they had. So this is the second piece of evidence. It was a very last witness during their rebuttal, a surprise witness who they didn't even know about. Thomas Patrick Smith came forward after Banfield took the stand. He was a supervisor of the defendant at the time of the murders. And he talked about this meeting that he heard Banfield talk about, and he said this isn't what happened. But take a listen. We've got both the testimony and his reaction.
The day was an important day for me at work as well. There was an important meeting for one of my cases. That meeting was scheduled for 9:30 that day.
To your knowledge, was there a meeting scheduled between yourself or with Juliet and Mr. Banfield on the morning of February 24th, 2023?
Leading.
Were you scheduled to meet with Mr. Banfield?
I was not.
Gabrielle, can your surprise witness be your best witness?
Your surprise witness can be your best witness. I think we knew that he was lying about the meeting before we brought someone in to prove that he was lying about the meeting. But I think
they prove it
further to his lack of credibility, right? And that's the issue. Everyone's credibility is at issue, and his credibility has been shot to hell from the minute he got on the stand. So it helped.
Let's move to the defense. We spent a lot of time talking about the prosecution, but there are two sides to this case, and the jury is weighing two sides. So here's a look at what our team picked as the best evidence that the defense put on, and that's the testimony from witness Brendan Miller. Miller was actually working as a digital forensics analyst for the government, and he was transferred from the case. And though he couldn't speak to the motives behind the transfer, he says it was related to his work on the case. So here's what he testified to. He said there was no indication that anyone else had any control over Christine's devices and the FetLife account, which goes against what the prosecution said about Brendan Banfield and the au pair being on her devices. Let's watch.
What were your conclusions in your executive summary that you wrote before her recant?
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner?
Christine Banfield.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
All right, Madeline, let's get your take on this defense evidence. He actually works for the government, so that's kind of a big deal that he's coming in and saying something opposite of the government.
I got enough from him. Like, that is enough for me. I think that the prosecution, when she came in and said, but could you tell conclusively that she was the one that was behind the device? And he said, no, that's the mic drop question. And I think when he said, first of all, his body language was sort of like a little kid who was in trouble, the way that he's sitting there. And if you look at his eyes, you can see that. But I think that he says, you know, at the time, the information that I had at the time, that's what I thought. The way that he's phrasing it is very careful, and that is a dead giveaway to me. If I'm the attorney sitting there, I point that out immediately.
And you know he definitely doesn't want to be there, likely. Yep. The defense is bringing him in to fit them into what the defense theory is. Marlo, I'm getting Karen Reed defense vibes on a much lower scale, though. But the argument from this defense is that all of these police officers, they colluded together because they wanted to bring Brendan Banfield down. And they had the group chat messages and things of that nature. And they've also got at least one person in the Karen Reed trial. They had one officer who said, I never saw a cracked taillight. So that can be really compelling to a juror or two.
It can, especially if they hammer reasonable doubt, right? Because that's going to come in. in, but my point kind of is, ask a better question, right? I mean, you have asked me better questions sitting here right now, and you saw the cop, right? He was like, and then he went ahead and answered what he thought he was going to ask. I mean, they just did not get the question out. And so if that's your best defense, that is your best evidence, ask a very clear, concise question. Although I agree, I don't know how that was leading, but...
Yeah, I had a reaction to that in the moment when I heard that she said leading. I was like, wait, how? What?
Right.
Yeah.
Gabrielle, let me get you to weigh in on whether or not this is the best defense evidence, or is there another contender that you saw during this trial?
It's my issue with the defense is we're almost there, right? So I think even the defendant's testimony could have worked for me, and I would have said that that was the best evidence if he was more transparent, right? He could have said, hey, my wife was bringing her work home and it was changing her desires in the bedroom. And to be fair, neither of us were saints. We both had issues with fidelity. They didn't do that. Similarly here, they could say she had control over these accounts. Here's an expert who's saying that they had control over the accounts. The jury doesn't have to buy either side's story. They have to determine whether or not the facts alleged met the elements. And if they feel like that happened, they don't have to work into whatever saga or whatever story either side wants to sell.
Another quick one we want to talk about that played to the defense, and the defense did lean into it, but didn't really talk about it necessarily during their closing arguments. But that's the fact that Christine was still breathing when the authorities got there. They were actively trying to save her life. Brendan Banfield said, I was trying to save her life. And we have this video of him reacting to finding out that she's deceased. But, you know, Marlo, he could have made sure that she was dead before calling 911. Is that compelling at all?
I have such a hard time with him and trying to determine whether it's compelling. I mean, that actually is more emotion than you saw on the stand. So I think that that is compelling evidence. I do think that, you know, the defense probably should have gotten him and prepped him a little bit better for why didn't you grab the towel? That's, you know, I mean, they just did not talk about that. And he's putting his hands, right? And so I thought the prosecution's cross with that was really good insofar as the towel was under your knee. Why are you just using your hands? And how she did that. And I think that even though you see his reaction and some emotion there that she is passed away, I think that really you needed a little bit more. Just, again, tell the story, tell it coherently and consistently, and, you know, don't put so much emphasis on how many times you cheated on your wife.
Great analysis from everyone. We have to leave it there. That jury, again, they start deliberating on Monday. Court TV will be there for everything. When we come back from this break, we're going beyond the gavel, and we're going to New York. No death penalty on the table anymore, but plenty still at stake in the case against Luigi Mangione. We'll talk about it next. Welcome back. We are taking you beyond the gavel, a major turn in a case against Luigi Mangione. A federal judge has ruled that prosecutors cannot seek the death penalty in the killing of United Healthcare CEO Brian Thompson, who was gunned down outside of a Manhattan hotel room last September. Now, the judge dismissed a federal murder charge, saying it was technically flawed, but left in place the stalking charges that the U.S. government brought. So those still carry the possibility of life in prison, but not the death penalty. Mangione has pleaded not guilty to not only those federal charges, but also the state murder charges against him. Now, jury selection in the federal case was set for September 8th, a couple of weeks ago. And now, state prosecutors this week, they are pushing for a July 1st trial date, meaning the state trial will go and then the federal will essentially go right after. And there was a win today for federal prosecutors. The judge ruled that prosecutors can use evidence collected from Mangione's backpack during his arrest. That includes a 9mm handgun, a notebook where he wrote down his thoughts and gave his manifesto of why he wanted to kill insurance executives. Mangione's lawyer sought sought to exclude those items, arguing the search was illegal because police hadn't yet obtained a warrant. So a lot of things going on in this case, which is still outside of the gavel because there's no trial that has started in this case yet, but many things happening. Let's bring back in our power panel. Madeline Somerville, Marlo Greer, and Gabrielle Higgins. Madeline, let me start with you on this case. Let's talk about the backpack search.
Sure.
That's something that is now coming in. The prosecution fought to keep it in. The defense wanted it out. What's your take?
Yeah, so the notebook evidence to me is the crucial piece there for a couple of reasons. One is because he wrote his manifesto in there, but one of the charges that they dismissed earlier on was a terrorism charge. And that was because when it comes to being a domestic terrorist, part of the definition, well, the definition, is that you are trying to change policy in what you're doing. You're trying to coerce the public into doing something, or trying to coerce a public official into doing something. So it has to be one of those three things. None of those things happened here. In the journal, he writes, "I just want to get this guy," or something like that, right? And he makes it very clear that it's not a case of terrorism, and that it's related to this specific instance here. And so that was actually a big part of it. So I thought it was interesting that it took so long for it to come in ultimately here as evidence at trial, because those are different standards. But I think with the manifesto here and the motive established, plus the stalking charges, he'll get the state charges for murder. I highly doubt he's getting out of that. But the death penalty being off the table is going to make a lot of people angry, but I do think it was the right ruling in the case.
Yeah, Marlo, let's talk about that. The federal case, that seemed to be the reason that they swooped in. Even though the state had their murder charges, they came in with their own terrorism charges trying to get that death penalty, and now it's off the table.
It's always something that they can use to make sure that maybe there's a better plea agreement, right? Because if there's a death penalty on the table, then a reasonable plea agreement is life in prison. But if there's no death penalty, life in prison versus life in prison, which is what he's going to get anyway, doesn't really matter. I mean, and it really teaches us here that if you're going to go a little cray-cray and you're going to write everything down, just read the law first to make sure it doesn't fit in the law, right? And
Maybe
then
that
exactly.
He was very smart.
Gabrielle Higgins, let's get your opinion on the suppression, well, not the suppression, the motion to suppress being denied for the defense, but then the death penalty now being off the table for the federal trial.
I think, first and foremost, just from a practitioner's perspective, it shows us the importance of handling a lot of these evidentiary issues up front. I think there's still an opportunity for the defense to request that this evidence comes in for a limited purpose and try to narrow in on the relevance, because it also has a very prejudicial nature to this type of evidence, generally speaking. I think, to your point about the death penalty being off the table, I agree. I think that there will be people that will be very angry, and I think there are people that will be very emboldened, quite frankly. I think that there is always a risk of creating a martyr when we have cases like this, and the public seems to gravitate to martyrs, as polarizing as they might be.
He continues to draw that support. Even yesterday, the reports of someone trying to break him out of federal prison.
That was so funny. I mean, it was terrible, but the weapons that he had were a barbecue fork and a pizza cutter?
Yeah.
I mean, it's not funny. It's a terrible thing.
And showed a driver's license when he was asked. He said he was with the FBI, but he still garners this support. And to Gabrielle's point, was the death penalty something that counteracted that in a way, do you think, in the grand scheme of things?
I don't think that it really counteracted the support in a way. I mean, I think there'll be still people that are going to support him, right? It really is reflective of healthcare in the United States, and there's a lot of people out there that are getting bills from their doctors that are thousands of dollars. I mean, I took my daughter to the ER. It was a $19,000 bill, $2,700 of which we still have to pay after insurance. And so everybody out there can really relate to him and what was happening to him. And even though, there's other reasons that I might talk about later that I think people gravitate towards him, it's really, hey, I could be that guy. I could be this guy suffering in pain and getting nowhere. I got a bill yesterday. My daughter's sick. There's how many movies are on this very premise?
Jury selection is going to be critical in this case because they will have to weed through people who feel a certain way about the industry. We've got to get to our break, but coming up, we're going to get the hot takes on the cold facts. Our panel giving us their opinions on the biggest headlines, including a lawyer slapped with a fine for asking Cardi B an off-limits question during her civil trial last year. We have the moment from court up next.
Tonight on Closing Arguments, 12 jurors are weighing the evidence in the Au Pair Affair murder trial. Court TV teams are on the ground with the latest Verdict Watch updates.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV. 9 hours of back-to-back true crime cases every Saturday.
This is crazy.
On America's original true crime obsession. 48 hours on Court TV. Saturday starting at 3/2 Central on Court TV.
Our Court of Opinion experts, they've got strong takes on all of the trials we bring you here on Court TV. And now we're going to get their hot takes on the big legal headlines. First, let's start with the cold hard facts on story number 1. Gabby Petito's family, they will have their case against the Moab Police Department heard in front of the Utah Supreme Court. You'll remember this case. It stems from a legal challenge, the dismissal of the family's wrongful death lawsuit against the police department that responded to this call. And it's also named against certain officers in the department. Now, Petito and her boyfriend, Brian Laundrie, they had a run-in with the police in August after a witness said that they saw Brian getting hit by a woman. Now, the Petito family, they've claimed that if officers had just followed the law that day, separated them, put someone in jail, then Gabby would still be alive.
We want to know the truth if he actually hit you. Because, you know.
I guess, yeah, but I hit him first.
Where did he hit you? Don't worry, just be honest.
He grabbed my face, I guess.
What was it you were attempting to accomplish by slapping?
I was trying to get him to stop killing me and come back.
Well, it doesn't sound to me like she attempted to injure him. It's your call.
All right, those oral arguments in that case are scheduled for March 4th. Let's get the hot takes from our panel. They each have 25 seconds on the clock to give us their take. Madeline Somerville, Marlo Greer, and Gabrielle Higgins. Madeline, I'll start with you. Your take?
Sure. So in the body language that I just saw there, I saw mostly honesty and somewhat fear, which makes sense in all of that. Here's the really tough thing, and because I've had cases where I've sued the government before. There's a sovereign immunity issue here, and blaming the police is a really, really difficult thing to do, but they have to make decisions in a snap second, and that's why they have that immunity. Here, this is a grieving family that's trying to get some justice, and this might be the only way they can do it, and the courts have to consider whether or not sovereign immunity is going to apply.
Marlo Greer, your take?
My take is going to be quicker. I think that officers need to be educated more on domestic violence. She admitted that she said, but I hit him first. That is a classic DV response. She's making excuses for him, and likely she's the one that's abused. They need to do that. What makes me really sad is I don't think the law's on their side on this one.
I know.
Gabrielle Higgins, civil rights attorney. Do you think these officers had enough information to make a different choice?
Well, number one, I'm always going to be an ally for sovereign immunity reform. I think that it's literally harming several families and preventing people from being able to get justice. I agree that until the laws change, the courts are bound to the laws as they are, and as they are, these officers are given protection for the split-second decisions that they make on the road. And I think in that moment, they thought they were helping her, not harming her.
All right, let's move to our next story. This one out of Washington, D.C. The Justice Department releasing more of the long-awaited investigative files relating to late sex offender Jeffrey Epstein. This was a massive document dump and included more than 3.5 million pages, 2,000 videos, 180,000 images. And among them, the DOJ released large quantities of commercial pornography, images that were seized from Epstein's devices. And there were some high-profile names, including the presidents, that were mentioned in those files. Some seem to be put up and then taken down. That's the reports that are swirling. Marlo, let me get your take on the dump itself. Is this going to appease the public?
I don't think it's going to appease the public until everything comes out. And as far as my hot take is, can I just not talk about sex for like 10 minutes? I mean, that's all we've been focused on. No one is really shocked about what is coming out with Epstein. We know what's in there, and it's just going to keep coming. And until it's just all out, I think everybody's going to nitpick it.
All right, Gabrielle Higgins, what's your take on the dump, what it does to the public's desire to see all of these documents? I mean, this is a really big one. Will this be the last one, or you think we will see more coming out in this case?
I think fake transparency is not transparency. And I think there is an agenda that is causing a lot of us to be polarized. And I think it's incredibly important for the viewers at home and everyone, quite frankly, to invest in increasing their media literacy. There's always going to be competing narratives, whether we're in the courts or we're in politics. And I think it's important to pay attention to not just the information, but what we're being told about what we should be looking at when we're surveying the information.
Madeline Somerville, your take.
It's extremely well said. And I agree with both of them about the last one. So my hot take here is actually about the attorney who was commenting on this today. His name escapes me right now, Todd Blanche. He was saying in response to a reporter, what men are you referring to? Because they were saying, when are we actually going to go after the men who abused these girls? He's like, which men are you talking about? You can't keep pulling the wool over our eyes. You're an attorney. Don't you feel any sort of ethical obligation to tell people the truth?
And we have to leave it there. Let's move to our third story. And this one out of California, a judge has sided with rapper Cardi B and fined a lawyer from her civil assault case last year. This was after a Los Angeles County jury ruled that Cardi B was not liable for assault and battery. Now, plaintiff Imani Ellis's attorney was fined $1,500 for asking an improper question during the testimony. Take a listen.
Do you have any affiliation at this time with a gang?
Objection, Your Honor. Motion to eliminate that violates motion to eliminate the order.
Suspend counsel, you know that.
If you didn't hear it, he was asking her about whether she was affiliated with a gang, and there was a violation that the defense attorney brought up there. So before the trial began, the judge ordered the attorneys not to bring up prior bad acts because it would be unduly prejudicial. Let's bring back in our guests, see what they think about that moment and a $1,500 fine for this attorney. Madeline, your take.
I'm very pleased with the outcome of this case. I'm very pleased with the fine. I loved everything about it. But I think here in particular, this attorney knew better. And the judge would not have imposed that fine if that attorney would not have he knew that attorney should have known not to do this. The worst thing you can do is make a judge angry like that. You never want to do something that's going to put that you're just trying to get in front of the jury so they can hear it and it stays with them and the judge knows that you know better.
Gabrielle, what's your take? Because that was some intense direct examination, but Cardi B, it just seemed to roll off her back. But your thoughts on a judge saying that a lawyer actually gets fined over one of those questions? Is that going too far?
No, I think if you play stupid games, you will most assuredly win stupid prizes. I think that if you didn't know the evidentiary rules that we're required to know, you certainly were clear on the judge's order prior to the trial starting. And if you weren't, the onus remains on the lawyer to get clarity about what is within the purview of their examination, what's permissible. So I think the attorney asked that question in a bout of lazy lawyering to get a rise out of Cardi or the jury.
Can we give a trial award to Cardi for being the kind of witness who did not react? I mean, there are some witnesses who they hear the question and then they answer it before their lawyer gets a chance to object, but she did not do that. Marlo, what's your final take?
She gets a trial award for everything there, right? But I am going to disagree with my colleagues a little bit here because I think as a lawyer, if you want that evidence in, you're going to dance on the head of a pin, right? And he did. He danced because the ruling was 404B evidence, facts from before, prior bad acts. Yeah. Well, he tried to say, are you affiliated with the gang at this time? So did he know? Absolutely. Was he dancing? Yes.
All right, that's where we have to leave it. Our thanks to our fantastic power panel tonight, Madeline Somerville, Marlo Greer, and Gabrielle Higgins. We appreciate you being with us here on Court of Opinion. Thank you for being with us this hour. I'm Julia Jenaé, reminding you we all have opinions. They should be rooted in facts, and we should be striving to respect the other's opinion even when we don't agree. That's what plays out here every night on Court of Opinion.